Hello, I'm attorney Joseph Niven. I'm here to talk to you about what it means when a court imputes income to somebody. So first, what is the definition of imputed income? When a court imputes income to somebody, what that means that the court bases its orders on a level of income that is generally higher than what the person says their income is. So for example, let's say that somebody says they make $50,000 per year. If the court issues orders of support and counsel fees based upon the party having income of $80,000 per year, then the court has imputed income of $80,000 to that person. So when does a court impute income to somebody? So a common scenario is that the court imputes minimum wage to somebody. So let's say that we have two people getting divorced and the husband makes $100,000 per year and the wife isn't working. The court may very well base orders of child support and maintenance on the wife being able to make minimum wage if the court finds there's no reason why the wife cannot work and the wife is capable of at least making minimum wage at the rate of 40 hours per week. Another scenario is based on earning capacity. So, for example, let's say that we have somebody that in 2019 earned $150,000 per year, and now in 2021 is saying they only earn $50,000 per year, and the court finds there's no adequate explanation for why it is that the person's income has gone down by 2/3. The court may very well then order that person to pay maintenance and child support and counsel fees based upon the prior income of $150,000 per year, because the court found the person is capable of making that amount and is simply choosing not to earn that amount and is unlikely to penalize the other side or the children for that choice by this party. Another reason is capability based upon education. So if we have somebody who, let's say, has a medical degree and is not practicing medicine and is making a lot less than what that person would have made had that person been practicing medicine, the court may determine how much that person would likely be earning if that person were practicing medicine, base orders of support and counsel fees on that amount. Another reason is, let's say that somebody has significant support from other people. So, for example, let's say that we have somebody who's capable of working but choosing to be supported by their parents, then the court can impute income based upon the amount that the court finds that person receives in support from his or her parents. Another reason could be perks. So, let's say that we have somebody who makes $80,000 per year but has an expense account where they're allowed to spend another $30,000 per year. Then the court can add 80 plus 30 and base orders of support and counsel fees on an income of $110,000 per year. Furthermore, there's also lifestyle. So if we have somebody who's self-employed, for example, declares $60,000 per year in taxes, but has $12,000 a month in expenses, then the court may very well find their income is at least $12,000 a month because they're obviously getting that from somewhere, unless they have tons and tons of debt, and thereby impute an income of $144,000 per year based upon $12,000 per month. So what's the effect? I've alluded to it throughout this presentation so far. The effect is that the court can use imputed income rather than simply the person's account of their own income to make orders of child support, maintenance, and counsel fees. So as you can probably tell, nobody wants to have income imputed to them. So how do we avoid it? Of course, there are arguments that can be made. So, for example, we take the example where we have somebody who is not working, and the court can impute minimum wage to that person. If I represent that person, I would likely take a shot at arguing, well, you know what? They made certain choices as a married couple. They agreed as a married couple that the husband would go to work and make the money, and the wife would stay at home with the children. And the court may or may not determine based upon that um, the court would not impute income to the wife in that instance, since her lack of income is based upon choices that they made as a married couple. However, what is most important is to act in good faith. So, if you're about to get divorced, then do not purposely lower your income to avoid support obligations. It's always a good thing also to actually declare the income that you make and not say, I make $60,000 per year, but then rack up personal expenses of $12,000 per month. It is always a lot easier if you are operating in good faith to avoid imputation of income. So if you have further questions, feel free to call us at 347 642 0376. You can also reach us via our website at www.nivenlaw.com. The first half hour is always free.